Hi, y'all, and welcome back. If you're new here, welcome and glad you found us. I am JoJo, and it is great to meet you. We are about to talk about another true crime case and hopefully see justice be done. But before we do, please hit that like button. And if you haven't already, click subscribe and turn your bell notifications to all so you can make sure to be notified when I post new videos. Thank you, everyone, for all your support. It means the world to me. Now sit back, kick off your shoes, grab your tissues and stress balls, and let's dive in. The content you are about to watch contains the subject matter of a real life true crime event. Therefore, it is not suitable for all ages and is only intended for adults. Hi, y'all, it's JoJo, and I'm back, and I am happy to report that I finally got my new mic in. Now, occasionally my AC will kick on inside my office, so you might hear a little background noise, so I do apologize for that, but as I promised, I would remake the video on Jake's third case once I got my new mic, because I really do apologize. The audio was absolutely horrible on that one. I am so sorry for that. I don't know what happened to my mic on that particular occasion, but I ended up using an old mic that I found to put out some other videos, and it seemed to be working okay, but I wanted to wait until I got my new mic to go ahead and redo this one. Well, it's here. I would like to hear what y'all think about the new sound and if you like the new mic. So anyways, moving along, it's actually a good thing that I'm remaking this video, because now that Jake and Rebecca have been officially charged with red rum for the unaliving of Emmanuel, now the record has actually changed, being that it is still an active case, as well as the first case for Jake has also changed. So I will be remaking that video as well. So this video is not only remaking the third case, but I pulled the newest version of the third case document. So you're going to get the newest version of the third case document. So let's go ahead and dive on in and get started. So we've got Jake Mitchell, or well, they have it as like Michael. They're missing the T. I don't know why. And you can't see my mouse yet. There we go. Now you can see my mouse. Surprise! Here I am. They're missing the T right here. I don't know if that was just a typo or why that ended up being, but regardless. And he was represented on this one as well by a private attorney, Vincent Hughes, which we've now seen Vincent Hughes in front of the cameras here recently. And now the custody status has changed. It is now in custody, and it is an active case, and the bail is set at $10,000 for this one. So I guess that's on top of the bail for the other ones, which, by the way, at the end of going through this case doc, we will be looking at their newest arrest record. I did go ahead and pull that this morning as well. So the original arrest date on this case was June 27th, 2024, and the filing date on this case was July 10th, 2024. There has been 5 continuances on this particular case to date. And there was 2 counts on this case. The first case was convicted felon and narcotic addict, own or possesses firearm, and that is a felony, and he pled not guilty, and it is active. And the second count was prohibited person, own, possesses ammunition, and that is also a felony, and he pled not guilty on that too. Surprise, surprise. And that one is still active as well. Now, it still has his hearing for the violation of probation listed as September 2nd, 2025 at 8:30 a.m. And then down here you will see right here, this is the new case number for the red rum charges, and there's actually a lot more charges to go along with the red rum, which you will see at the end of this video. The arraignment hearing for those charges is on September 4th, 2025 at 8:30 a.m. And here's his bail information where it says that his bail is set at $10,000. And the original date filed for that bail was December 13th, 2024. Now, it says that the status is exonerated on that bail. So let's just take a look at what bond exonerated means. I pulled this up earlier and it says an exonerated bail is one that is officially released by the court, ending all financial and legal obligations for the defendant, their co-signer, and the bail bond company. This happens when the defendant successfully completes all their court appearances and their case is resolved, such as through a verdict, plea, or dismissal. Once a bond is exonerated, the defendant is no longer liable for that bond. And if collateral was posted, it can be returned to the person who provided it. So I'm assuming that the reason why they put the status as exonerated for this particular bail amount is because of the fact that he originally posted bail on this VOP the day that he was arrested for it, which we will read here in a minute. And now they're exonerating that bail so that it can now be released, being that he is now in the custody of the detention center. I guess that's the reason why they exonerated it and released the bond amount. I'm no lawyer or anything like that. I've never even been to prison myself. Maybe one of y'all have more experience with this and you can kind of clear things up for me and maybe put that down in the comments for me. So we're going to go ahead and move all along down to the bottom because as we know in their infinite wisdom, they decide to go ahead and put the oldest date all the way down on the bottom. So we got to go all the way to the bottom in order to get to the beginning of the story. So 7/2/2024, this is where the bail bond was filed and the appearance date was set originally for August 9th, 2024. And right here you can see where the bond was posted that same day, 7/2/2024, and it was posted for $10,000. And then 7/2/2024, it shows that he was released on June 27th, 2024, which was the same exact day that he was arrested for the VOP. And then it mentions the appearance date again as being 8/9/2024. And the complaint was filed on 7/10/2024, and it was done electronically. So now we go up here on August 9th, 2024 was when he had his arraignment at 8:30 a.m. And it was the Honorable Judge Francisco Navarro was presiding over that one. The defendant was represented by Private Vincent Hughes once again. So I guess that he kept this attorney throughout the whole entire process. And the defendant was present. Now, this I don't quite understand. Why would he not declare his true name and an arraignment? I just don't get that one. Please help me understand. Make it make sense. Why in a court of law would you not declare your true name? Anyway, discovery was provided to defense counsel, and defense counsel did acknowledge receipt of that discovery. And the defendant's counsel waives the formal arraignment, and then counsel for defendant waives formal reading of complaint and stipulates defendant has been advised of his or her legal and constitutional rights. And of course, the defendant pled not guilty to all charges. Felony settlement conference was then set for October 7th, 2024 at 8:30 a.m. And the custody status at that point was the bail bond was continued. So he continued to remain on bail. And then right here we've got 8/9/2024 protective order law enforcement body worn camera evidence filed. I would love to get my hands on that, but unfortunately they didn't even give me the option for that. So that's something that I'm going to have to put in a FOIA request for, and hopefully they will get it to me without costing too much money. Now here we are on October 7th, 2024, felony statement conference at 8:30 a.m. The Honorable Judge Francisco Navarro presiding. So that's the same judge that we seen at the last one. Defendant represented by Private Vincent Hughes. Once again, defendant is present. Now here we go with continuances. Defense motion to continue pursuant to 1050 PC is granted. Motion to continue is not opposed by the people. people. Hearing continued to December 13th, 2024 at 8:30. Reason for continuance? More preparation needed by defense. At least it's so much better than reason for continuance other, which I've seen so many times in these cases. Custody status information, he continues to remain out on bail. And here we are at December 13th, 2024. Felony statement conference again at 8:30 a.m. Honorable Judge Francisco Navarro presiding. Defendant represented by Private Vincent Hughes. Once again, defendant is present. I think that he learned from case number 2. He needs to actually show up at these hearings. Otherwise, they put out arrest warrants for his behind. Mandatory settlement conference set for 4/25/25 at 13:30, which, if y'all don't know military time, that is 1:30 in the afternoon. Custody status information, he continues to remain out on bail. Now we're at April 25th, 2025, mandatory settlement conference at 1:30 p.m. Honorable George Hernandez, judge, private counsel, Private Vincent Hughes, present in court representing the defendant. Defendant is present. Stat code, mandatory settlement conference not conducted. Parties were not ready. Defense motion to continue pursuant to PC 1050 is granted. Motion to continue is not opposed by the people. Hearing continued to 7/2/25 at 8:30 a.m. Pursuant to PC 1050D, the court finds good cause has been shown to grant the continuance. Reason for continuance. There's that other again, which I don't understand why they put that. I mean, they got right there. Stat code. Mandatory statement conference not conducted. Parties were not ready. Why not put that in the reason for continuance? That the parties were not ready. Why do they got to put other? It makes no sense to me. Now, I want to go ahead and dive into what a mandatory settlement conference is for those who do not know. It is commonly referred to as an MSC, and it is a court-ordered meeting before a trial where parties in a lawsuit represented by their attorneys attempt to resolve the dispute through negotiation. The conference is led by a judge or an attorney acting as a neutral settlement officer, aiming to avoid the lengthy and costly process of a trial by finding a mutually agreeable solution. While not every issue may be fully resolved, the MSC provides a final opportunity for compromise and settlement, potentially limiting the scope of issues for trial. So could this be like his last-ditch effort to make that plea to the judge to be able to kind of like just dismiss these charges, or to prevent him from getting that suspended sentence slapped onto him because of the fact that he totally screwed up again? From my understanding, being that he had a suspended sentence and this VOP from the first case, so technically when he got arrested on this VOP, he should have went to jail and got that 6-year suspended sentence slapped onto him, and he should have went to jail for 6 years. He should not have been able to bail out. I don't understand why they even let him bail out. I don't know exactly how the court system works in California, but it's just my understanding that if he ever screwed up while he was on probation under that sentence, that sentence would automatically slap down on his head the minute that he screwed up that first time. But you know what didn't happen? And guess what ended up happening instead? He got let out on bond, a measly $10,000 bond. He got released on $10,000 bond, and he went out there, ended up having baby Emmanuel, and look what he did to him. Just let that sink in for a minute. It makes me so mad. I just want to spit nails. But let's move on. Okay, where was I? Oh yeah. Custody status information. Of course, he continued to remain out on bail. July 2nd, 2025, Mandatory Settlement Conference at 8:30 a.m. Honorable George Hernandez, Judge. Defendant is present. And in this one, there was a special appearance by Private not even going to try, Mr. Maureen for Private Vincent Hughes. So Vincent Hughes wasn't even there that day. He had somebody else set in for him. So whoever this guy is. And then again, here we go. We have stat code, mandatory settlement conference not conducted. Parties were not ready. And then so we have another continuance. Defense motion to continue pursuant to PC 1050 is granted. Motion to continue is not opposed by the people. Hearing continued to September 2nd, 2025 at 8:30 a.m. Pursuant to PC 1050D, the court finds good cause has been shown to grant the continuance. Reason for continuance, other, which we already know. It should not be other. It should be parties were not ready. Hello? McFly. Anyway, custody status information. Bail bond is still continued, so he's still out on bail. And of course, we know September 2nd, it is coming up, but we're not quite sure if they are going to continue to keep that date or if everything's just going to be done on September 4th. And then on 8/26/2025, ex parte hearing status. Here again, I wasn't quite sure what an ex parte hearing was, so I went ahead and I looked that up as well. So I'm going to go ahead and share what that means with y'all in case y'all didn't know either. So an ex parte hearing is a court hearing where only one party is present and represented, occurring without prior notice to the other side due to an emergency. The Latin term ex parte means from one party. These hearings are used in emergencies to get temporary orders to prevent immediate, irreparable harm, such as in cases of DV or child endangerment, which basically suits this case. While an ex parte order is temporary, a full hearing will be held later so the absent party can be heard. And they say it's temporary, but how temporary is it? This is where the Honorable George Hernandez, Judge, ended up on court's own motion. He recused himself. Gee, I wonder why he recused himself from the hearing in this case, pursuant to CCP 170.3. So let's go ahead and look that up real quick. I'll be right back. I'm back, and that code, CCP 170.3, this is current as of January 1, 2024. It says, if a judge determines himself or herself to be disqualified, the judge shall notify the presiding judge of the court of his or her recusal and shall not further participate in the proceedings except as provided in section 170.4 unless his or her disqualification is waived by the parties as provided in subdivision B. 2, if the judge disqualifies himself or herself is the only judge or the presiding judge of the court, the notification shall be sent to the person having authority to assign another judge to replace the disqualified judge. It doesn't really say why. B1, a judge who determines himself or herself to be disqualified after disclosing the basis for his or her disqualification on the record may ask the parties and their attorneys whether they wish to waive the disqualification except where the basis for disqualification is also provided in paragraph 2. A waiver of disqualification shall recite the basis for the disqualification and is effective only when signed by all parties and their attorneys and filed in the record. 2, there shall be no waiver of disqualification if the basis therefore is either of the following: the judge has a personal bias or prejudice concerning the party, or B, the judge served as an attorney in the matter in controversy, or the judge has been a material witness concerning the matter. Okay, it's a lot of legalese here. Essentially, it looks like more than likely he's just recusing himself because of the fact of being on the prior case, and with everything that's been going on with the case and what happened in the prior case, he just figured that there was too much of a conflict here and it was just best just to recuse himself and take himself out of the equation and let a new judge come into play, which, hey, I am more than happy to see him recuse himself. So we're going to go ahead and move on here. And it looks like we have another ex parte case on the same exact day at the same exact time. Okay, so the ex parte hearing was held at 8:30 a.m. on the day that they were originally supposed to be in their hearing, because their original hearing, I think, was at 8 o'clock, if I'm not mistaken. Let me pull that up real quick. Hold on just 1 minute. I'll be right back. Okay, I'm back. Yes. Okay, the original hearing was 8/26, 2025, and it was supposed to be at 8 o'clock in the morning. That is probably why their hearing got pushed up to 1:30 in the afternoon, because of the fact that this judge here had his ex parte hearing set at 8:30 in the morning. So they had to go through and do this ex parte hearing. Now, this is just all speculation on my part, so no facts here, just speculation, just putting it out there, disclaimer. But he had that set at 8:30, and then you can see right here, trial readiness conference set for 8/26, 2025 at 1:30 p.m. And then this is the case number for that one. Now, I did look up also what a trial readiness conference is, and we haven't went over that one yet. But a trial readiness conference is a court hearing held shortly before a trial to ensure both parties are prepared to proceed. At the conference, the judge, prosecution, and defense attorneys discuss the status of the case, confirming whether proper paperwork is filed and served, determine if all evidence, discovery is exchanged, and identify any outstanding issues. The goal is to streamline the trial process, resolve cases if possible through plea bargains, or confirm the trial date. That makes sense. Basically like a pre-trial hearing, essentially. I guess they just call it something different over there in California. Okay, so moving on. And then you got this second ex parte hearing on 8/26 at 8:30. It was in regards to reassignment. So this is where they had to reassign a new judge, which the new judge is now Honorable Gail O'Rain. Am I saying that correctly? I hope. And then, of course, it mentions the trial readiness conference set for 8/26/25 at 1:30 p.m. So let's go ahead and move on up. And we've got 8/26, 2025 mandatory settlement conference rescheduled for 9/2/2025 at 8:30 a.m. Oh, from 9/2. Oh, so the only thing they did here is they just changed the department. So it is still scheduled for 9/2/2025 at 8:30 a.m., but they just changed the departments from B304 to Department 61. I wonder why they did that. And then they also ended up rescheduling the trial readiness conference, was rescheduled from 8/26/25 at 1:30 p.m. in Department 53 to 8/26/25 at 1:30 p.m. in Department 61. So there again, they just changed the department. They did not change the date or time. So now we're at the trial readiness conference at 1:30 p.m. on 8/26/25. Now, this is a different judge from the one that they say that they ended up reassigning to the case. Interesting, because they have here that they reassigned Honorable Gail O'Rain, but up here, the trial readiness conference is the Honorable Gary Pope. Okay, and it says defendant is present. Trial readiness conference set for, okay, so I guess he was just like a temporary judge because they weren't really doing anything anyways. They were just doing a continuance at that particular hearing. Okay. Trial readiness conference set for September 4th, 2025 at 8:30 a.m. in Department 61. And then custody status. Bail bond, the first bail bond is exonerated, and then bail bond set in the amount of $10,000. So the original bail bond was exonerated, and then now he has a new bail set at the same amount of $10,000 just for this case. So then all of his bails, I guess, just kind of add up. So he ain't getting out of prison anytime soon. I doubt there's any way that he's going to be able to afford all of these bails in order to get himself out, because for the red room charges, I know those were like $1 million. So yeah, he had to be able to afford those plus this plus the bond amount for the original first case, and then any other charges that they ended up slapping on him too, which, like I said, at the end of this, we're going to go ahead and get to that too. We're going to take a look at their newest charges, in which we're almost done with this. We're basically at the end of this one. And so we got 8/26/2025, bail bond exonerated, which we just talked about. And then 8/26/2025, this is the detention center that he is staying in. It is the Robert Presley Detention Center. 9/2/2025 is when his mandatory settlement conference will be at 8:30 a.m. and that will be in Department 61. And then on 9/4/2025, that's when his trial readiness conference will be at 8:30 a.m. in Department 61 as well. And then we have 7/2/2026. Bail bond is to be addressed by 7/2/2026, which is 2 years from effective date of 7/2/2024. So that is this bail bond number up here, which was the one that was exonerated. So I don't quite understand what they mean by that. Maybe one of y'all can help me out down there in the comments if you've had anybody that you know that has ever dealt with doing a bail bond, or you've done it yourself, or anything like that, or you're in the legal field and you know more about this stuff. Maybe you can help me out and explain a little bit to me about how bail bonds work. I would appreciate it, but we're going to go ahead and move on from here. And now we're going to take a look at their newest charges. So now, as you can see here, we got Jake on the left and we got Rebecca on the right. Now, if you look at Jake's, you can see that he's got 187A, which is a felony, and it is red rum with malice. And it just says disposition is 825. Quite sure what that means, but it doesn't have any bail. So does that mean that it's a no bail charge, which means he wouldn't be able to get out of prison regardless, even if he did post bail on the other charges? Is that what that means? Because these other ones have bail, but that one doesn't. So is that a no bail charge? And he has that on here twice. See, you got this one right here, and then you also got it down here as well, which this one shows $1 million bond, and this one's showing nothing. And they're both the same exact charge code. So that's odd. Could that just be a misprint, maybe? Maybe because this was his original charge before they added all the other charges in. Interesting. And then they added this charge here, which is a misdemeanor. This is 148.5A, false report of crime, which they're giving him $1 million bond on a misdemeanor. Not that I'm complaining now or anything, but wow, that's pretty high for a misdemeanor. For just a false report of a crime, it is interesting. And then we've got down here 273A. It's a felony, willful harm child, which that actually stems from that first case of his, which he got the VOP on, and where he brutally injured Promise Faith, his little 10-week-old baby, which is now 7 years old and essentially can do nothing for herself and is going to need constant care for the rest of her life because of that monster. But that is only, and I do say only, $35,000 bond. And that's what it originally was too. Now really, let that sink in. Not to mention what he ended up getting as far as sentencing on that case. It was 1,000% a total failure, if you ask me. But I will be redoing that video as well because we do have new information on the docs for that case as well after I get done with this one. So be on the lookout for that video to come out soon. And then we have a 29800A1, which is another felony, which is felony possessing firearm, which is a $10,000 bond. And that is from the case that we just went over. And then he also has 30305A1, which is another felony, and that's prohibited own, etc., ammunition, etc., and that's $10,000 bond, and that's also from the case that we just went over. And then this one here, 300, which is a misdemeanor, and it just says depth child jurisdiction. Quite sure what that one is, but it's no bond. It's just all zeroed out. You see that there. And that's I mean, these here are all PC for booking type. I'm guessing probable cause. And then it says W and I. So maybe I should look those up real quick. I'll be right back. Okay, well, I'm back. Well, first of all, I did find out that the PC under the booking type does not stand for probable cause as I thought. In California, the booking type context of PC actually stands for penal code. That refers to the section of California law under which a person is being booked for a criminal offense rather than the crime itself. For example, booking for trespassing would be listed PC 602, referring to the specific penal code statute for that crime. So in other words, then, so this would be PC and this would be the penal code charge number. That clears that part up. But now, this is where it gets a little confusing to me. We come down to this final charge here, this W and I, and this 300. Whoops, didn't mean to do that. Sorry about that, folks. But we come down to this, and that's where it gets a little confusing to me, because when I looked that up, it says in jail booking records, the abbreviation W and I stands for Welfare and Institutions Code. This indicates that the booking relates to juvenile or dependent court matters rather than adult criminal charges. I don't quite understand that, because with the W and I 300, it says this covers cases involving dependent children. The booking could be for a minor who has suffered or is at risk of serious harm due to neglect or the failure of a parent or guardian to provide proper care. But it says after that, if W and I appears on a booking record, the person in question is a juvenile and their case will be handled by the juvenile court, not the adult criminal justice system. So I don't understand why that would be on Jake's record. I mean, I understand W and I 300 because that does say that this covers cases involving dependent children. And it says the booking could be for a minor who has suffered or is at risk of serious harm due to neglect or the failure of a parent or guardian to provide proper care. So that perfectly fits this situation, and I get that. But it says if W and I appears on a booking record, the person in question is a juvenile. He is not a juvenile, and this case will not be handled in juvenile court. So that's where my confusion is. So if anybody can help me out with this, then please, can you put it down in the comments? Because that's got me a little perplexed right there. I don't quite understand why they would be putting that on his record. Wouldn't there be some kind of code that would be for an adult's booking record that would cover the same thing? I would think. Anyhow, we got to go ahead and move on. I don't want to make this video too god-awful long. So let's go on to Rebecca's now. Over here on Rebecca's, which is the one on the right, you can see that she has the 187A, which is a felony, the red rum with malice, just like Jake. And there again, hers has no bail listed. It doesn't even have any where it's just zeroed out. And here again, if you look down at the bottom, she has the same thing, the W and I 300. So I don't get that. But anyway, we're going to move on from that one. We've already discussed that. So the 187A felony, and that's red rum with malice. And then she also has the 148.5A, which we see that Jake also has that, which is the false report of a crime. And that is, again, $1 million bond, which really surprises me for a misdemeanor. Like I said before, not complaining. And then you got the 187A, which is a felony, and that is red rum first degree, which is slightly different from what Jake has. Jake has 187A, but they have it listed as red rum with malice. She has it listed as red rum first degree, but they still both have the same bail, and that's $1 million. So there you have it. There's their newest charges, and I went ahead and I redid Jake's case number 3, and now Jake's working on his case number 4. So I will also be probably putting out a video on case number 4, but I don't want to do it just yet because there's still so much more that's going to be coming out on that case. So it kind of seems pointless to do it at this point. I'm going to go ahead and wait probably till after the plea is put in at least. And then maybe I might do a video, do just a short one on that one. We'll see. But keep a lookout because I will be putting out a new video on case number 1, being that there is new information in that case. So with that being said, catch you on the flip side. And thank you very much, everyone, for all of your support. And yay to 50 subscribers and rising, because I noticed that we are over 50 now. I really do appreciate everybody's support, and stay safe, stay happy. Bye-bye, y'all.